to the Fit for Privacy Podcast with Punit Bhatia. This is the podcast for those who care about their privacy. Here, your host, Punit Bhatia, has conversations with industry leaders about their perspectives, ideas, and opinions relating to privacy, data protection, and related matters. Be aware that the views and opinions expressed in this podcast are not legal advice. Let us get started.
China recently passed a data protection bill, and there are a lot of questions around that. And also, the topic of data transfer remains hot in Europe. How about talking about these two topics with the legal counsel and head of data protection and privacy practice from DLA Piper? And I'm talking about none other than Heidi Waem. And we are going to have a fascinating conversation with her. Let's go. So, welcome, Heidi. Good to have you.
Thank you. Happy to be here.
So let's start with the standard question, which I usually ask, and we as privacy professionals often get into describing GDPR, and we can spend hours and days about it. But when you think of GDPR, what's the one word that comes to your mind?
Challenging.
Challenging. Wow, what a profound word. It is indeed very, very, very challenging. And I don't need to ask why it is challenging. We all understand. But today we are not going to talk about GDPR. We are going to talk about the Chinese data protection law and the data transfers. And when we talk about the Chinese data protection laws, most people say, in fact, it has become a fashion that whenever we talk about a new data protection law, we say, oh, it's similar to GDPR. And yes, they are similar because GDPR is so comprehensive, so framework-oriented, principle-oriented, that you can't have a privacy law without falling back or relying on the principles that GDPR has. But how do you see the similarities between the Chinese data protection law and the EU GDPR?
Well, in terms of similarities, when you will look at the obligations under PIPL, and we will go into that in a minute, you will see lots of familiar things. You have an extraterritorial effect, you have some processing principles. So you have lots of obligations that look similar, but to really call it similar to GDPR or the Chinese GDPR, I understand that's not entirely correct because PIPL, let's say it's a piece of a very large puzzle. In China, you have a very comprehensive framework with regard to data, with regard to security. And the data laws, they don't only cover personal data, but also other types of data. And so PIPL sits somewhere in that big framework. And what it does is that it consolidates and it clarifies a number of obligations that were already in other laws. But so it's a piece of the puzzle. It's an important piece, but it's not, as I understand it, it's not like GDPR, where that is really the comprehensive framework, and then you may have some things on the side or underneath that. So in that aspect, it's certainly different. What will also be different, as I understand from my Asian colleagues, is how they will apply and enforce it in practice. It still remains to be seen because it's fairly recent, but it will probably not be applied and enforced in the same way as we do, as Europe does with GDPR, or as local data protection authorities do with GDPR, because of the different nature, actually, and also the different culture in Asia, which is a lot different from the culture in Europe.
Okay, so it's similar because it's a privacy law, but broadly speaking, we don't know how it will apply, and you find it different. So help us understand, and you mentioned an important thing, that it's part of the puzzle. So help us demystify this puzzle a little bit by helping us understand a few of the key or building blocks or requirements, as we call it, of this Chinese data protection law.
Yeah, so as I said, it also has an extraterritorial effect, because you must know when drafting the PIPL, China really looked also at GDPR. I think that's clear, and other Asian companies do that too. So I believe they may have gleaned that from Europe, that extraterritorial fact, and so they try, as far as I understand it, with PIPL to protect mainland China residents. So when they are abroad, and if you would be focusing on those residents and you would be processing their personal data, for example, in the context of analytics or providing products, things that resonate with people that know GDPR. And so it also works with definitions which are a bit similar as under GDPR. They have a definition of personal information. So it's personal information or personal data, but which also relates to information with regard to an identified or identifiable natural person. So that is also very similar, of course. They have a definition for sensitive personal information, which is a bit different from GDPR. But so they also distinguish like this separate category of sensitive personal information.
Mm-hmm.
Besides that, we see a number of processing principles. Again, very familiar. Fairness, you have something on accuracy, you have something on retention. There's a transparency obligation, as I would call it. It's the notice obligation, but that was already before in other laws, I understand. So you have a number of principles. You have in a certain way purpose restriction or data minimization, which are closely linked. So these things are all familiar. When you work with third parties, with processors, you should also enter into a contract. They have some rules on data transfers, which is a very hot topic in the EU, well, and everywhere, I think. So where they also have certain restrictions on data transfers. They will have kind of their own standard contractual clauses, but I understand they are not yet issued. But you can also transfer personal data, I understand, if you have passed a certain security evaluation, or if you have gone through a certain accreditation procedure or certification procedure. So again, all very familiar. But it remains to be seen a bit how it will be applied and enforced in practice. So yeah, that's a bit the main obligations. Also something on incident response. You have notification obligations to the regulator, to data subjects, a number of rights. Also right to access data, things like that. So yeah, basically when you hear me telling this, you will think, wow, it's a totally similar to GDPR. But as I said, it looks like GDPR, but it's yeah, it will probably, and of course I'm not a Chinese qualified lawyer, and I'm European, so we look at it from our culture, but it is a different culture in Asia, so it will be interpreted and applied in line with how they look at privacy and the protection of personal data.
Absolutely. I think when we look at a privacy law, end of the day, it's a privacy law. It talks about all the relevant things. You can't define personal data much differently. You can define sensitive data a little bit differently. You can always say which rights you have, but you need to provide the basic rights. So essentially, these are the same elements. The stricter rules or the details is where it matters. And it's like the cars. I mean, whether it's a Ferrari or a Mercedes or a BMW or whichever, it has 4 wheels, it has a bonnet, it has an engine, it has 2 or 4 doors, it has seats, and it gets you from one place to another. But it's the experience within which determines how the car is. And that's what the privacy laws are. It's the culture of that country, culture of that geography. Remember, India is also working on privacy law for a long time. The first version looked like as if it's a shortened version of GDPR, abstracted into few pages. And when I looked at the second or the third version, there were so many exceptions. It doesn't apply to state, it doesn't apply this, doesn't apply this. So essentially the few leftover private companies that they will have to, still have to see how it shapes up. But again, you can always start with GDPR, but as you end up, and then when you implement it, it really, really changes the meaning. But when we look at Asian laws, and especially China as well, there seems to be, and help me understand if it is the case with Chinese law also, there seems to be an over-reliance on consent. I mean, some of the laws in privacy laws in Asia, they even tend to think contract is a consent, while in the European sense of it, contract is not consent. Contract you sign and then it's there. Consent in our language, European language, you give and you take back. Contract you don't take back. So our definition, and again, the cultural thing, consent is very, very, very different. But Chinese or even most Asian colleagues tend to rely on consent. Even the Indian privacy law says you should have consent in form of a contract, while for us, contract and consent are two separate bases. So how do you see this? And if you can enlighten us based on your study of other jurisdictions, why is it so that they rely so much, especially in Asia, on consent? Is there a specific reason, or maybe it's cultural?
It's I understand the cultural thing, and that they let's say they it's more of a community culture, so to say, and not focused so much on the private individual. So for them, the community is important, and yes, people also, because of that community idea, their expectation in terms of privacy and as a private individual is different, and so they rely on consent. It has been like that, and I understand that it will remain like that. And for them, consent is also in a certain way more straightforward than consent under GDPR, because you know, consent under GDPR, it comes with a lot of conditions. It has to be informed, has to be specific, and so on. But there, it's more like it's given or not. It's just more straightforward. You ask for consent, and they give it or they don't give it, but it doesn't not necessarily have to be like informed and specific and meet all these requirements like under GDPR. It's more straightforward. If you look at PIPL, they do distinguish some other legal bases, but I understand it's let's say also more more on paper, or in a sense that these are exceptions more. So the, let's say for the bulk processing activities, you would need consent, and then in certain limited instances you could do without consent and rely on another legal basis, which is of course totally different, because under GDPR, as you know very well, you have 6 and they are equally important, or at least that's the idea. Although we do tend to see in practice a bit of hierarchy, but in the idea is basically that they are 6, that they have the same value, so to say, and you just have to choose the appropriate one. But in Asia, it's predominantly consent, and it will remain like that. And apparently what I understand from colleagues there is that even if something would be based on contract or something else, is that they would still ask for consent, because it's within their culture. But I also understand that in a certain way it works, that people in China, they grew up, and especially the younger generation, with apps and so on, and that they understand, let's say, that when they give their data, that there's something in exchange that's a more personalized service, or that they can have a discount or something like that. So that's a bit the thing with consent. It's for us in Europe, I think it's a bit hard to grasp, because we are so in the GDPR system with the 6 legal bases, which were already there under the directive. So it's for a very long time that we're living with that, and also with this idea that consent has to meet certain conditions. But I think, it's just the way it is. We have different cultures in this world, and we have to, to try and understand probably, and maybe not, always think that our approach is the better one. It's just a different approach, but as long as it works, and what I understand, it works, because I think the IPL and the privacy laws in China and the other laws, they are, let's say, mainly focused on like preventing abuse of data, which is probably a bit of a different angle. Of course, GDPR also wants to prevent abuse, but it's more the main angle is like to empower citizens, and to give rights. So it's a different approach, but we can say it's, I think, a more straightforward approach than what we see on the GDPR, because you have to identify the correct legal basis, which of course with legal obligation and contract, I think that is not always so challenging, unless if you want to push a lot or bring a lot under a contract. But it's more like when you come in a legitimate interest and things like that it might become a bit complicated. And then of course, if you have a system which is mainly consent based, and then it's more straightforward in a certain way, I believe, in terms of compliance also.
Yeah, it gets straightforward, or it gets complex based on which perspective we take.
Yeah.
Because it reminds me of the story of privacy notice when I was designing a privacy notice, and we were designing it for multiple countries. And it was so fascinating to see in Europe, we want it to be an instrument which demonstrates transparency, while other countries also say it demonstrates transparency. But then in the US, the United States, they look at it as a legal document, which has to be legally well worded, and it has to protect you in the court of law. And then in most Asian countries, they also expect you to collect consent that the privacy notice has been accepted. And when you change it, they want you to notify and ask for consent that, yes, I have agreed to terms and conditions, which is quite different from the way we are doing it in the EU GDPR. It is fascinating to see how people are playing with the same requirement. We still call it transparency, we still call it notice, but the way it's executed, even in the way it's written or explained, even in Europe itself, based on culture, I mean, Netherlands is far more open and transparent and direct language with the customer, while in Germany, a little bit, it's more tight and succinct and more. So it's very fascinating to see these requirements, and especially when you mention consent. But when we look at this law, you mentioned that consent is a straightforward choice, or legal basis is more straightforward. What are these strengths of this law, the Chinese law?
Well, if you look at it from, let's say, the China legal framework point of view, is that it brings apparently lots of clarification, items that were unclear under existing laws, that it clarifies a number of items. It's clear on certain obligations. So yeah, I think I believe that's the main achievement of PIPL, although it's in a certain way also principle based, and of course some uncertainty may remain, and they expect additional recommendations like we have in Europe. But that is what I understand. It clarifies a lot of things. It also makes clear that it's that the CAC, the Cyber Administration, is the relevant regulator. And so, because before, I understand it's also in terms of regulators, it's a complex constellation also in China, and so it's probably consolidation and clarification on a number of things, which of course is helpful for companies doing business in China, setting up a compliance program there, because we all know if things are unclear, and we have lots of things that are unclear also under GDPR, it's not always easy to set something up. So I believe that's the main strength.
And do they have what we call in the EU GDPR something like a DPO or an EU representative kind of thing in the Chinese law also?
Yeah, they have a similar DPO requirement, but I understood it was already before PIPL there, but it seems to come with, let's say, less strict requirements than the DPO under the GDPR. But indeed, it's yeah, it's a figure under PIPL too, the DPO, and also important for companies doing business there to have someone, let's say, as a DPO, to have someone there, which preferably, what I understand, speaks Chinese, which is important to communicate with the regulator. But it's again a similarity with GDPR. And also what I understood is also it's challenging to find one, because it's a bit like the same in the market in EU. Lots of companies need a DPO. There's more demand than offer on the market, and apparently I understand in China it's the same. Many companies are looking for a person. So yeah, there's definitely job opportunities for people wanting to be a DPO in China if you speak Chinese. And
I think the key word is if you speak Chinese.
Yes.
Yeah, but that's interesting. And maybe as you mentioned that the territorial rights and data transfers, even in context of the EU GDPR, I mean, when I look at it, it's a mess. That's how I see it. Okay, I'm exaggerating a bit, but after this comes to, and then this new standard contractual clauses, I was thinking it'll make it simpler, but it has made it more complex, because it says you should do a transfer risk assessment, no problem with that. Document the risk, no problem with that. Mitigate risks. Now, we all know if I'm transferring data to the US and the big tech, I have an email, I have a SharePoint, I have this, and I have that and that. All those carry the same risk, whatever company you choose. Now, and the US government always retains the right to get the data. So how does one protect or mitigate that risk? It's practically, in my opinion, it's not possible, but I like to have your opinion, and maybe start with what challenges do you see or observe when talking to other companies or people in context of data transfers? Because data transfers is more and more becoming a challenge, because more countries, like you mentioned, Chinese law also, they're bringing in either a data residency or sometimes confused as data sovereignty requirements, saying data should stay here. But we all know in a cloud world, cloud is cloud. It doesn't have any boundaries. It's not the European cloud and the US cloud. Of course, we can do that. It's very complex. So what challenges do you see people struggling with?
Well, as you said, I think it's a bit a mess also. I fully agree. The transfer story. And the challenge is just that it's we live in an interconnected world. It's a digital world. It's a global world. But if you look at Schrems too, and in a certain way, I do understand the decision, of course. If you look at SECs and the way adequate protection and the way we look at privacy, and then you see, of course, it's protected here, but when your data travels, it needs to remain protected. And I do understand it in a certain way, but there's this other reality. The reality is just different. I mean, it's interconnected. We're digital. We're global. And then I think it's one thing to do the transfer impact assessment, indeed, and maybe to think it through a bit better. There's probably a benefit in that. I think it was the same with the data mapping that we needed when GDPR entered into force. I think there was a benefit in that in a certain way, because lots of companies had kind of blind spots, and then when doing data mapping, they thought about processing activities and thinking like, do we really need to do this, or can we change this, or can we optimize it? So in a certain way, there's a benefit in there. I think just to look at your transfers and look and do an impact assessment, and maybe look indeed at supplemental measures, maybe that you would, I don't know, maybe without Schrems 2, we would not think about it so actively. So there's in a certain way, but I believe, and maybe they could not do it otherwise, but I believe that the court, in combination with the EDPB recommendations, that it just went too far in a certain way, because if you look at how it is applied, it's in a very, what I always call a bit an absolutistic way. And then certainly if you look to the EDPB recommendations, where I do believe, and it's really my belief and a lot of other people, that it's not enough risk-based approach, even if we saw now in the recent Austrian decision that they don't take it into account. But so it's not enough risk-based, and if you look at the examples on the supplementary measures and what is proposed, it's in a certain way to become desperate, if I can say it like that, because you're looking at it, and I strongly believe that most companies, they really want to comply, they really want to be accountable, and they want to do their work, but it's in a certain way also made almost impossible with this very absolutistic way on looking to access and data in the clear. And again, there might be a benefit to look at certain transfers and say, okay, maybe we haven't thought enough about encryption, or maybe we haven't, I don't know, looked at pseudonymization or whatever else techniques. But there's also a whole lot of companies that live in a reality where they have service centers outside of the European Union, and which I understand, and I'm of course not an IT person, but that you need access in the clear. Or you have lots of companies that have outsourced their IT to foreign countries, where of course sometimes you have people then from those foreign countries working here in Belgium, but also accessing from abroad, which obviously need access to data in the clear, because otherwise they cannot do their work. And even if there are ways, of course, to limit it, and I'm really convinced that all companies and all big vendors and all IT providers, they're doing their best, but there's only so much you can do. I mean, you have to keep your company operational. You have to keep on working. And so, yeah, I found where with Schrems 2, I think I tried to understand what the court did, and I mean, they gave some pointers like how you should assess it, but for me, the EDPB recommendations, they just went too far. They are a bit, yeah, as I said before, too absolutistic, and make lots of things impossible, and yeah, then companies want to comply, and you do things, of course, and I guess you will be advising the same to your clients, indeed, do the assessments and document it, but in a certain way, yeah, the feeling remains like, okay, whatever we'll do, it will be hard. And linked to that, I believe it's really, and we talked about culture before, it's in a certain way a clash of cultures, and in my view, it's in a large part a geopolitical thing.
It is a geopolitical
it is a geopolitical thing, and to me, it's like Europe has to solve that, and it's not. I can't see how companies can solve that, and so you see things like where you saw the case in France. Then it even goes further than even in cases where you don't have an actual transfer, because Schrems 2 is clearly about a transfer within the meaning as we know it, and now with the new guidelines we know what's a transfer. But then even if you don't transfer, if you take an EU instance, if you don't take support from outside of the EU, and then they say, like, yeah, but this possibility of the Cloud Act, and then you still have to do an assessment, and then I think, yeah, it never ends. So then even when keeping in EU, it's then not sufficient. And I really have difficulties with it. It just because it's a geopolitical issue. You're asking companies to solve it, which they can't. They can't.
At government level, you cannot. How can we at consulting or company level solve it? If they can't get a privacy shield equivalent signed, what do they expect without the government to government agreement? How can we get an agreement for our contract with a company which is anyways bound by the laws of that country? It's like passing the buck. But are there any solutions? You mentioned pseudonymization, you mentioned encryption, and you also mentioned some, of course, there are some contractual measures, and also some companies are suggesting to clients that we will set up a dedicated data center and the US entity will not have access. But I mean, how far does it go? Are these real solutions? Are these really being implemented?
Well, you see, and I assume you see that too, indeed, certain solutions are implemented, of course, because people are doing the assessment, considering supplementary measures. But the real solution would be just like adequacy decisions for many countries. I think that would be the real solutions, because if you look at the EDBB recommendations, again, even if you look at the use cases where they talk about encryption and pseudonymization, I don't know now by heart all the conditions, but I mean, if you look at those conditions, then you read them and then you think, like, I think there's one of the conditions saying, like, yeah, you must be sure that some authority does not hold any other data or cannot break the encryption, or at least it boils down to that. And then I'm like, interesting, but how do we have to call like the NSA and say, like, oh, do you think you can decrypt? I'm exaggerating and maybe making a bit fun of it, but it's you read it and then you think, okay, even if we use encryption, probably we will not be able to meet all these requirements. I think key management with the controller is a kind of a solution, but these things like, is there a possibility that someone can decrypt? To be honest, I don't know. I don't know. Probably. I mean, there probably maybe there are some regimes that in their on the military side that they have like very advanced techniques, or so. How far do you want companies to go? So I think there are solutions to mitigate, of course, certain risks, but it in a certain way, I think it boils down to de facto data localization almost, that you keep your data in Europe, but then bearing in mind that there are things as the Cloud Act, but which is also, I found it, I still find it a bit peculiar. Like in Europe, we don't like that Cloud Act has extraterritorial effect because we see it as a threat, but we also like extraterritorial effects in European laws. So probably not in the same way, but I mean, it's a difficult discussion, and I don't know what your experience is there, but with clients, it's not always an easy discussion, and certainly not, as you said, if you work with clients from US or also from other jurisdictions outside of Europe, it's sometimes it's hard because it's just like that. I have lots of companies that have headquarters in the US or maybe in another country and that have data in that other country and not in the EU. So yeah, it's a bit of a mess. And then maybe one other point I wanted to touch upon is you mentioned we have the new SECs, and then in a certain way it helps because you have this extra clauses already there, and you have the obligation to do the TIA. But then, of course, it remains a contract, like with the old SECs. It doesn't bind authorities. But then you have this odd scope of application of the SECs to importers, like not subject to the GDPR while processing operations, because as an importer as such, you cannot be subject. And then you go like, but what does it mean? I mean, so, and what do you do with processing activities subject to GDPR? So you can't use them. But so how is that then a solution, or why did they make them like that? Well, why we didn't have that under the old ones. I understand why they made it like that, because of course the territorial scope, it changed under the GDPR, but it's not, I mean, it's, you have to try and explain that like to contract managers in a company. It's very challenging, and it's not helpful in a certain way, because who is going to assess it, whether a processing activity is subject or not? How are you going to assess it? What do you do then if you have various processing activities? Well, I think in practice, and happy to hear how you do it. I think in practice we just conclude them, well, regardless of whether it's subject or not, because it's difficult to make the split. But there's every step that is taken, like with the decision and the EPB recommendations and the SECs, it becomes more complicated. So I'm already sometimes afraid to see what will be next. What will be the next step?
It's surprising that everyone has the same opinion, but those who had to decide, they decided otherwise. Or maybe they were also bound by the law because they can't give adequacy to US, because if they give, there's a next level of SCUM 2, now 3, now 4, and then 5 that continues. So that's also an issue. But to close your eyes and just put in a theoretical position, that's also not going to help. And that is one area which is a mess, because when you're explaining it to a C-level, they're like, so what are you telling me? There is a risk, but I have to make a choice. And in function of business, there's no other credible alternative for doing business. So I have to say, let me take the risk. So what's the point? So all you end up doing is the theoretical exercise. Say, let's do a transfer risk assessment. Let's document the risk. Let's identify the mitigation actions, take it to the management to accept it, and maybe implement some supplemental measures, again, based on the size and scale of the company. And then use the standard contractual clauses, maybe a DPA, and that's all. But where does it leave you? Does it mitigate the risk? Can you go and stand in front of the CEO and say, your risk is protected? And that's where the challenge is for most of us. We cannot say that. To say we've documented the risk, we've done the best we could, but everyone is in the same position. Everyone has the same risk. And the only advantage is if one of these companies is breached, then it's very highly unlikely that all of us would be fined at the same time, because it would be all of us in the same boat.
Yeah. No, it's what you said. It just indeed, it will be a different conversation with the regulator if you have everything in place, but then still there's something, as opposed to if you just don't do anything. I think it will be a different conversation, but indeed, there's only so much you can do, and even if you would try to change certain things, if you say, okay, I don't know, it's outsourced to, I will not name a country, but whatever country outside of Europe, or we have a service center somewhere else, even if you would say, okay, maybe we need to look for another solution, it's not something, it's totally unrealistic to think that a company can decide that from one day to another. I mean, you have contracts for many years. If it goes for outsourcing contracts, I mean, it's huge budgets. It requires, it's not something, sometimes it feels like they think it's like, oh, you just have to like switch off a button and then you stop the transfer. But it just it doesn't work like
No.
that. Yeah,
It's challenging. It's very challenging. But I think the usual ones I play on is I say, okay, here you have to document the risk and demonstrate accountability. So as long as you have evidenced that you did what was possible for you, the best possible solution, considered the supplemental measures, implemented where possible, documented it, and kept a trail of why you decided to go ahead. Like sometimes you don't have a credible alternative to a cloud solution which you are looking for, or
that's true.
a collaboration solution you're looking for, you don't have a credible alternative. And then they say, in view of all these factors and the consequent risk of not doing it, because one is the risk of doing it, but other is the opportunity or cost, as we call it in business. The risk of not doing is it even greater, because then you're losing out on competitive advantage. So those are the decisions, or those are the things which you play on, and then say, let's play the accountability card, and we did our best what we could together with the business. That's where it ends up. And now that we've talked about the Chinese law and the data transfers, which is a little bit of a sticky topic, let's move to the last section that is more, I call it fun, but how can we have fun between somebody like me and you being a lawyer? I mean, that's not the right combination in my view.
I don't know.
Let's try. So if you were to choose, we were talking about the European approach being more human-centric and saying, let's prevent or let's empower the individual with rights and everything. And that's how the laws are structured. And then we have the Chinese or most Asian countries, wherein it's to prevent abuse and prevent misuse of data, which is the other side of spectrum. Call it preventive and reactive or something like that. So one is very advanced in one way and the other is very advanced in another way. Which one would you choose? More the European kind of approach, being saying empowerment, versus worrying about the abuse of data and then protecting it? Which one would you choose?
As a European, I choose the empowerment.
No surprise.
Yeah, we choose the, it is important for us. So yeah.
It is important. And then we were talking about consent, and that again has two dimensions. One is consent is very liberal, withdrawable, and all those things. We know the story of EU GDPR or UK GDPR. And then we have the very strict consent around, it's more or less a contract. It's signed, it's done and dusted, and withdrawal is basically closing down your services, as simple as. So it's you called it relatively straightforward. So if you were to choose the two levels of consent, which one would you choose?
Well, I'll go for the other one now, the straightforward one.
So I expected it again for the balance of it. So that's how privacy professional and a lawyer have fun, fun conversation. Okay, now a little bit building on it and asking you, if you were to put your personal data and sensitive data, would you put it in US cloud, Chinese cloud? There's no or.
Oh, I thought there was a third option.
The third one would be EU, but then you will choose the EU, so I can't give you that.
Let's go for US then.
Okay.
Yeah.
Okay. Indeed, because anyhow, most of the tech companies are in US, so the data is more likely to go.
Indeed. I've been to the US, not to China. It's maybe a reason. I don't know. I would choose the US cloud then. Yeah.
Good. So it didn't feel like that the time has passed, but it has passed, and especially the last few questions feel like we should have more of them. But so I would say, Heidi, thank you so much for your time. It was wonderful to have you. And if somebody wants to contact you, what would be the best way to contact you?
By email or phone. My details are just freely available on the internet.
So much for personal data protection.
Indeed.
Okay. So thank you so much. It was wonderful to have you.
It was great to be here. Thanks a lot.
Fit for Privacy helps you to create a culture of privacy and manage risks by creating, defining, and implementing a privacy strategy that includes delivering scenario-based training for your staff. We also help those who are looking to get certified in CIPPE, CIPM, and CIPT through on-demand courses that help you prepare and practice for certification exam. Want to know more? Visit www.fit4privacy.com. That's www.FIT4privacy.com. Thanks for listening. If you liked the show, feel free to share it with a friend and write a review. If you have already done so, thank you so much. And if you did not like the show, don't bother and forget about it. Take care and stay safe. Until next time, goodbye. If you have questions or suggestions, feel free to drop an email at hello@fit4privacy.com. That's hello@FIT4privacy.com.